broadcast is now starting. All attendees are in listen-only mode.
Welcome to Legal Governance Challenges for Associations During a Pandemic, sponsored by the Association Societies Alliance and your local Society of Association Executives. My name is Mark McSween, and I serve as the Executive Director of the Association Societies Alliance. ASA is the Association for Chief Executives of the Societies of Association Executives across the country. Collectively, our members represent more than 4,000 trade, professional, and individual membership associations in 39 states and New Zealand. For everyone listening to today's webinar, the odds are that your Society of Association Executives Executive Director is a member of ASA. Before we get started, I do have a couple of housekeeping items. There is a handout that is available in your Handouts tab along the right side of your screen. If you have any questions during the webinar today, please enter those into the question box, also should be along the right-hand side of your screen. Jeff anticipates having about 30 minutes at the end of this session for Q&A, so we'll get to as many of those as we possibly can. Immediately following the webinar, you will receive a short three-question survey that will ask you just a couple of questions about the seminar, as well as your interest in additional future topics. Additionally, a recording of today's webinar will be available tomorrow, along with a link to Jeff's article on this very topic. With that, I would now like to introduce today's speaker. Jeff Tenenbaum is one of the nation's leading nonprofit attorneys, and also is an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C. based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the recipient of the 2006 American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and is one of only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. With that, I'm pleased to introduce to you Jeff Tenenbaum. Jeff?
Thank you very much. Good afternoon, everyone, or good morning to those of you on the West Coast. Welcome to our webinar today, Legal Governance Challenges for Associations During a Pandemic. We have a lot of material to cover today in a relatively short time. I'm going to do my best to get through as much as I can in enough time to be able to allow a lot of time for questions. This is a topic that I've always done for the 25 years I've been practicing law, always done an extensive amount of work. Every association attorney does in the governance area. And I know from all of that experience that it gives rise to many, many, many questions. In part because everything is so fact specific. Most areas of law tend to be, but some are more fact specific than others. Here, the issues and the analysis and the considerations are going to vary significantly based on what state you're incorporated in, your association is incorporated in, of course, whether you have members or not, what your articles of incorporation and your bylaws say about a number of these governance provisions, and how that all interrelates to each other. That makes it complicated, sometimes confusing, and it will generate a lot of questions, and we're going to try to reserve about half the time today for your questions. Now, that being said, here's our agenda for today. The focus of today's webinar is on the impact of the COVID-19 pandemic on association governance practices, with, for those of you who know me, a real focus on practical ways and solutions to try to adapt. In this area, frankly, in most areas of law, I find it's obviously very important to understand kind of the legal basics and the legal construct and the overview and the basic principles to get a good handle on it. But of course, what you really want are practical solutions to solve these problems and overcome these challenges and be able to move ahead with the governance decisions and meetings and actions and other things that your association needs and wants to take, despite the fact that you might have some hurdles in the way from some of these legal obstacles. Some of the specifics we're going to get into: bylaw requirements for an annual meeting in the event of a canceled or postponed conference. I'm going to talk about the options for virtual meetings and/or electronic voting outside of a meeting by the association's membership. Talk about some state actions to allow for increased flexibility in association governance. The sometimes need to amend your articles of incorporation to allow for additional flexibility in governance. The consequences of not following governance procedures or applicable state law, and then board action through proxies and/or electronic voting. You can probably already see from just this agenda alone how complex and nuanced this is. And so I want you to kind of pay attention carefully as I'm going through some of the basics. And that there's key distinctions between meetings and voting or other actions outside of a meeting. So those are two different things. Having a meeting, an actual meeting, and voting or taking action outside of a meeting. And then on top of it, those same two distinctions are usually have different rules with respect to member action, member meetings, and member voting compared to board meetings and board voting. This is an area that there's always been a lot of confusion about. I think one of the first articles I ever wrote, probably 25 years ago when I started practicing, was a short one-page article about some of these issues, because I got so many questions from clients even early on who got confused between these things. And it doesn't help the fact that so many of the state nonprofit corporation laws treat member actions and board actions very differently, some for good reason, and some for no good reason at all, as we're going to get into. So that's going to make it a little bit more complex to follow, but please pay attention to those distinctions. Even this morning, I was talking to a client, and we were talking about some proposed revisions to bylaws, and he was asking about the notice requirement in the bylaws. And he was sure that this other organization put out a notice period that was too short because the statute in the particular state of incorporation required 10 days minimum notice, he thought, and they had only provided 7 days, and he was looking for ways to challenge it. But it turned out the statutory provision about notice and minimum notice for a meeting, and this is to talk about bylaw amendments, was 10 days for membership meetings, but with respect to board meetings, the statute said that the bylaws can put any notice period that you want to. So in fact, that minimum 10-day notice period only applied to the membership meetings, did not apply to board meetings. The bylaws themselves provided for a 7-day notice period, so it was fine. So it's a good example of how it's really important to distinguish between member actions and member meetings and board meetings and board action. Okay. So, sorry about that. All right, let's give you a little overview of kind of how all of this works and how it fits together. So the first thing that you always have to look to here, first thing that most associations look to is their bylaws, right? But the reality, as an association lawyer, the first thing I always look to when I'm trying to figure out a governance question or a governance issue is the state nonprofit corporation statute of the state in which the association is incorporated. Because that is the ultimate guide. That's the ultimate authority about what you can and can't do from a governance perspective. Doesn't matter where you're located. It matters where the association is incorporated. And many, many times an association is incorporated in one state where it started out, and then it ends up moving, once or twice, and it's located, headquartered now in another state. But in any event, it doesn't matter. What matters is the state in which you're incorporated. That is the state that is going to govern. That's the state statute that's going to govern. All of these state nonprofit corporation statutes are loosely modeled after the American Bar Association's Model Nonprofit Corporation Act, but for better or for worse, and probably for worse, most of them vary in some ways very significantly, in some ways less significantly from the Model Nonprofit Corporation Act. And that Model Nonprofit Corporation Act, the American Bar Association is constantly, kind of every few years or so, revising it and putting out updates. They're working on a major revision to it right now. They do a terrific job. I've been involved in that process to a certain extent. It's a very, very thoughtful process that they undergo. But unfortunately, not all states follow all of those recommendations. And as a result, the state nonprofit corporation statutes, some of them really vary significantly from state to state when it comes to these issues. But that's what you need to look to. Now, this is, I apologize, there's a typo here in the second bullet point, but there's a hierarchy in association governance documents, and I have listed the hierarchy in kind of these sub-bullet points. And everything that is below what's above has to be consistent with what's above. So your board-approved policies have to be consistent with your bylaws have to be consistent with your articles of incorporation, and your articles of incorporation have to be consistent with the state nonprofit corporation statute of your state of incorporation. If anything below is inconsistent with what's above, and when I say inconsistent, I'm saying where something above it says you have to do it this way or you can't do it this way, a flat-out prohibition or prescription or mandate to do things in a certain way, if a document that's below it is inconsistent with that, it'll have no force or effect. Now, a lot of times, things like the state nonprofit corporation statute will say things like, I don't know, let's say a quorum for membership meetings. It'll say, that a quorum shall be a majority of all voting members unless the articles of incorporation or bylaws of the association of the corporation say otherwise. So in a lot of cases in the state statutes, there'll be a default provision, but then that default provision doesn't come into play if the bylaws provide that a quorum of, for membership meetings is 20% of all voting members. But in other cases, for instance, the state nonprofit corporation statute in most states, Texas is one exception, but in most states says that proxy voting by board members is not permitted. And neither is voting by board members. You can't take like an email ballot outside of a meeting in most states. And I'll get into that a little bit later. It says, if the statute says you're not allowed to do it, then if you had a provision in your bylaws that says board members can vote by proxy, or they can send substitutes, or they can take a vote outside of a meeting by email or mail ballot, that provision would have no force and effect because it would be inconsistent with what's in the state nonprofit corporation statute. Obviously, the same goes, with what's in your policies versus what's in your bylaws. Generally speaking, policies are going to have more detail than what is in the bylaws. That's kind of a best practice, and that's usually how it works. And then that final bullet point I've already covered. Next slide. So for your annual meetings, and I refer here to an annual meeting, not only because most associations have what they call an annual meeting, but because state nonprofit corporation statutes, most of them hire an annual meeting for both your membership as well as your board, 2 separate annual meetings. But that being said, most state nonprofit corporation statutes provide that the failure to hold an annual or regular membership meeting will not affect the validity of any corporate action. So if you fail to hold an annual meeting, even though the statute says you have to hold an annual meeting, if you fail to hold one, it's not like any action taken after that is going to be null and void. Most of the statutes make that clear. In addition, obviously in the face of the pandemic, many, if not most, in-person membership meetings and association meetings generally, at least through the first half of the year and likely further, are not happening and probably will continue to not happen. If you had, your annual conference, your annual annual membership meeting or other large regular membership meeting that was supposed to occur during that time and it's gotten canceled or postponed, and that was the meeting at which you have the election of, say, officers or directors, if you're in an association where the members elect the officers and or directors, then in a situation like that, generally speaking, where the members elect officers and directors, you can, in most states, you can generally make that occur through an email ballot without a meeting. So in other words, hold the election, even though you might typically do it in connection with an actual in-person meeting. You can generally just simply have that election via email ballot. Now, of course, if your bylaws themselves are very prescriptive and make, say, unusually crystal clear that that's not permitted, that could arguably be a problem. And then one other thing to keep note that most people don't know, it's not really intuitive, but if your board elections do not take place via email, say because you're in one of those states where, or your own bylaws just simply don't permit it. Most of the state statutes say that despite the expiration of a director's term, the director shall continue to serve until the director's successor is elected, appointed, or designated, and until the director's successor takes office, unless otherwise provided in the articles or bylaws. So basically what that means is that if a director's term expires and a replacement has not been elected or appointed yet, that unless your articles or bylaws say otherwise, that person will continue to serve, will continue to validly hold that office and be able to exercise the authority of that office. Next slide. Sorry. Virtual membership meetings and voting. So when I say virtual membership meetings, I'm sure you all know what I mean, but I'm referring to some sort of an electronic meeting, whether it's a video call like this one on GoToWebinar or Zoom or something like that, or some sort of an audio conference meeting. But what I'm trying to distinguish here, and this is a really important point to make, is the distinguishment between a meeting and voting outside of a meeting. So while most state nonprofit corporation statutes permit members in lieu of voting at a meeting to vote by written ballot, and most of them allow that electronically now. Back in the day, they're always referred to mail ballot, and they're doing ballots by mail. Starting probably 15 years ago, I'd say, a number of the state statutes started to amend their statutes to make clear that mail also encompassed email. Some of them expressly, even if it doesn't. I think the general consensus has been that as long as you can verify the identity of someone sending an email, that an electronic ballot through whatever method, whether it's by email or some sort of electronic voting mechanism, is sufficient. So we're talking now about membership voting in lieu of it at an actual meeting, but to do it outside of a meeting by written ballot. But sometimes the path to get there can be a bit tricky. Now, this is why, because some of the state statutes allow email voting. And when I say email voting, I don't necessarily mean by a classic email. In fact, most associations don't use actual email to do electronic balloting. They use one of these technology platforms that allows members to vote electronically. I should clarify that in this PowerPoint. But when I say that, that's what I'm referring to, any sort of an electronic voting method. So some states say that email voting is fine unless the association's articles or bylaws prohibit it. So if it's not prohibited, some of the statutes allow it to happen. Some statutes also allow, so that's voting outside of a meeting. Some state statutes allow virtual membership meetings, different from a mere electronic vote, but rather an actual online meeting. Again, so long as the association's articles or bylaws do not prohibit it. Now, some states, or DC is not a state, but a jurisdiction, where I happen to be, like the District of Columbia, only permit a virtual online meeting if the articles or bylaws expressly authorize it to happen. This is actually a bit unusual. It's actually a bit frustrating because DC, I think, otherwise has probably the best and most flexible nonprofit corporate statute. And even the chair of the American Bar Association's the drafting committee for the Model Nonprofit Corporation Act believes that as well. But this is one of those provisions that really needs to be updated in the DC Act because it doesn't allow it unless the articles or bylaws expressly authorize it. And I dealt with a situation recently where a client's articles or bylaws did not expressly authorize it, and that's a problem. Some states do the same for email voting as well, electronic voting outside of a meeting. And then finally, some state statutes require permitting virtual meetings to be contained in the Articles of Incorporation specifically in order to be permissible, which is obviously a very frustrating situation that you might find yourself in. Of course, if the articles were already amended to allow for virtual membership meetings, then it's a non-issue. But if they have not been amended, and then if they have to be amended, most state nonprofit corporation statutes require that the members vote. If you have voting members, the members have to vote to amend your articles of incorporation. So to get there, you'd have to have a membership vote in order to allow a virtual meeting of the members to occur in order to amend your articles of incorporation. So it can be really difficult if you're in that situation. And then some states, like New York's nonprofit corporation statute, which is not one of my favorites. No, I love New York. No offense to New York, but they have one of the worst nonprofit corporation statutes, and so does California, by the way. Two states that I'm fans of, but not with respect to their nonprofit corporate laws. New York does not permit virtual membership meetings at all. A little more on this. So membership voting by ballot versus by proxy. Now, these are similar, and in fact, they really kind of, the way that things work these days with electronic voting, they kind of look and smell the same, and you might even have a difference distinguishing between them. But it is an important legal distinction. Almost all state nonprofit corporation statutes permit membership voting in connection with an actual meeting, whether it's in person or virtual, to occur by proxy. And generally, that proxy can be given electronically. A proxy meaning I'm giving my vote either wide open, vote however you want to the chair or to any particular individual member, or I'm giving what's called a directed proxy, meaning I'm giving my vote, to the chair, but to vote on this way on these issues or for these candidates or whatever the case may be. So that's generally permitted in virtually every state to allow electronic proxy voting for membership meetings. But when it comes to membership action outside of a meeting, the state statutes do differ. And so if you're in a situation where your state statute does not permit electronic membership voting outside of a meeting, but it does allow for electronic proxy voting in connection with a meeting, one solution that we've done, once in a while with clients in kind of rare situations where we had no choice is to kind of technically have a meeting, but only maybe one person actually physically shows up in person and everyone else is participating by proxy. And so essentially looks like an electronic ballot outside of a meeting, but technically it's done through that mechanism, through that construct, in order to be able to be consistent with the state law and your own bylaws. Again, very critical to distinguish membership voting from board of director voting by email, ballot, or proxy, because in most states, again, Texas accepted, and I think one or two other states, prohibit board of director electronic voting outside of a meeting unless it constitutes what's called unanimous written consent, which means all of the board members vote, they all vote in writing, and they all vote the same way. That's considered unanimous written consent. That's allowed and provided for by every state nonprofit corporation statute, I believe so at least. But most states do not allow for electronic voting or proxy voting by boards. So distinguish the boards, but from membership, the boards are generally much more restrictive. And then focus on the statutory provisions that require the unanimous written consent of all members versus those that just require a quorum of voting members. Because obviously, as all of you can imagine, if you had to get the unanimous written consent of all members, it's going to be practically impossible in every situation. But if you just have to get essentially a quorum to vote electronically, and then a majority of those voting, or whatever the threshold of approval is, majority, 2/3, usually it's going to be a majority will carry the day, that's much more doable. But believe it or not, a lot of these state statutes still do refer to unanimous written consent for member votes as an alternative. Usually they have other mechanisms as well, but just pay attention to that because that's just not going to work for virtually any association. State modifications to nonprofit corporation statutes. There's not much of this going on. As I stated earlier, some states do not allow for virtual membership meetings at all. However, we have seen during this pandemic that a number of states, as well as the federal government, of course, have made a number of changes through executive orders and other executive actions to various legal requirements in order to provide more flexibility. The most notable one that I'm aware of is fairly recently, maybe as long as a month ago now, New York Governor Andrew Cuomo issued an executive order to allow membership meetings for New York nonprofit corporations to be held remotely or by electronic means. So that's not actually permitted in the New York not-for-profit corporation statute, but he issued an executive order to allow that for obvious reasons. So while all states may not go this route, it's important to keep an eye out and do your homework for any executive actions that might provide a little more flexibility. Should we amend our Articles of Incorporation? So like I said earlier, the nonprofit corporate statute in your state of incorporation may require that in order to take advantage of some of these more permissive provisions for electronic balloting and whatnot, that has to be provided for or allowed for in your articles of incorporation and not just your bylaws. As I mentioned earlier, that can be difficult sometimes, particularly in the current environment, because amendments to the articles generally have to be approved by the voting members of the association and not just by the board. And that's by statute. The statutes generally require that. So if your association decides that it wants to amend its articles of incorporation to allow for something more flexible, you have to go through these motions. It's a real pain in the neck, and I've had to do it a number of times in the past. In order to get more flexibility and permissiveness with respect to member actions or sometimes even board actions. If the statute says it has to be in your articles, then you got to figure out how do we lawfully amend our articles in order to get there. I had one situation once where I forget if it was the statute or the articles or bylaws did not permit for essentially electronic voting by the members outside of a meeting, but it did allow for proxy voting and proxies to be submitted electronically by members. So in order to amend the articles to have the more permissive provision put in there to allow for electronic voting by members, we did what I said earlier. We had kind of that one person holding a meeting and everyone else participated and submitted their proxies electronically. And actually that worked to achieve the desired goal. What happens if you don't follow kind of that governance hierarchy? As I said earlier, if something is mandated or prohibited by state law or your association's own articles or bylaws, any action taken inconsistent with them is going to have no legal force or effect. Theoretically, it could later be challenged by an aggrieved board member, a member, or even the state attorney general for your state of incorporation. And while this does not happen frequently, any of these things, it does happen once in a while, and I've been involved in cases involving all three of these things: an aggrieved board member, aggrieved members, and even fairly recently a case involving the Minnesota State Attorney General getting involved in some of these issues, some of these governance issues. It does happen sometimes, and particularly where you have a lot of conflict going on in your association, you have warring factions or whatnot, that's usually where this comes about, or you just have one really aggrieved board member or member. You do have to be concerned about these things. Most of the time, is anyone really going to care or do something about it? Most of the time not, but of course that's not going to be your general MO for not following the law or your own governance documents. But one other option is if you can't achieve something because of some of these hurdles, I could give you examples, but I think you know what I'm talking about by now. If you can't achieve one of those goals because of some of these legal or governance document related hurdles, it may be possible for you to just go ahead with whatever action you're going to take and later have it ratified at a future meeting of the membership or a future meeting of the board in order to kind of legitimize further reliance on those actions and have it ratified retroactively. It's never an ideal situation to do this, but it's something we've done. I've done it numerous times in the past. Sometimes if, for instance, I've done it with boards and with members actually, if you can't do the formal vote for some reason, you could take kind of an informal poll to try to get a sense of the board or a sense of the membership as to how they want to do things. Rely on that, go ahead and make the changes, take the action, and then later when you do have the next formal board meeting or membership meeting, have them ratify that decision retroactively. And I don't know why that went backwards or the wrong way. My apologies. I think that was it. So why don't I stop there right on schedule, and let's turn to your questions. So why don't you guys start posing your questions if you haven't already. Oh, I see them in there. And Mark, if you want to start kind of posing some questions to me, and then we can get into some of the details and some examples and hopefully help to illustrate some of these points in ways that make sense to everyone.
Sure. So one of the first questions asked early on was that if there is no annual meeting at all due to COVID-19, can bylaws be changed can bylaw changes be made via email?
So of course, the answer is it depends, and it depends on what state the entity is incorporated in, and it depends on what your bylaws say. So, if your bylaws say that some action has to be taken at an annual meeting of the members, then it's not likely that you would be able to take an action outside of a meeting, like doing some sort of an electronic voting of the members. Because, as I said earlier, if your bylaws or your articles specifically require to be at that meeting, that's the way it would presumably have to be. Now, if it doesn't say it has to be at the meeting, a lot of these provisions in bylaws and in the state statutes say any action that could be taken at a meeting can be taken outside of a meeting through electronic voting outside of the meeting or for a board unanimous written consent. And so unless it's specifically prohibited or specifically mandated in the bylaws that it has to be at the annual meeting, then it's likely, again, I'd want to check the bylaw provision specifically in the state statute that's applicable, but it's likely that you would probably be able, in most states at least, to be able to take that action outside of a meeting through some sort of an electronic ballot.
Great, thank you. What about affiliation agreements? Where do affiliation agreements fit in the list of hierarchy, right below the nonprofit statutes?
So are we talking about affiliation agreements with chapters or affiliation agreements with related affiliated entities like foundations? What are we referring to?
That's a great question, Jeff. This doesn't specifically state that.
Well, it's a great question because it illustrates a couple of points. First off, as you know, a lot of associations have related foundations, they have taxable subsidiaries, other affiliated entities. And they're often linked to the association through some sort of a written affiliation agreement. And that is a contract, and that is going to govern things. Sometimes it governs governance things. Like, for instance, an affiliation agreement between an association and a related foundation may provide that the board or executive committee of the association has the right to appoint and remove the officers and directors of the foundation. And that also, if it's bound, if it's required contractually, that also should be reflected in the foundation's bylaws. But ultimately, each entity is going to have its own kind of separate hierarchy. Its governing documents are going to be governed by that same hierarchy that I described earlier for the association. You just have the overlay of the contractual obligation. So the same thing is going to go for chapters. Assuming chapters are separate legal entities, that's not always the case, but the vast majority of associations have chapters that are separate legal entities, usually incorporated as nonprofit corporations as well. So if it's a chapter is a separate legal entity, it has its own state nonprofit corporation statute where it's incorporated, it's got its own articles, its own bylaws, its own policies, governed by that same hierarchy. But if it has an affiliation agreement with the National Association, for instance, and that affiliation says, defines how the board is going to be comprised and who can serve on it, or how many members, minimum, maximum, how they get appointed or elected or removed, all of those things are sometimes put into chapter affiliation agreements. That's a contractual obligation, so the chapter needs to be sure that its governance documents comply with all of that. Otherwise, it could find itself in breach of contract, and the association, the National Association, could have a claim against the chapter. So that's generally how it works. It's a great question because it doesn't neatly fit into some level on that hierarchy, but it absolutely factors in. And while it may not be something that would be problematic from complying with the state nonprofit corporation statute, it would definitely be problematic if the chapter is breaching its contractual obligation to the National Association.
Great. What kind of advice can we provide our chapter leaders on these topics? Where's the legal advice line versus this is my opinion on what I read in the statutes?
So it's a great question. Even I remember back in the day, I worked at ASAE in the public policy division and later managing the legal section when I was going to law school at night. And that's a dangerous thing. I was a lawyer in training, and I was answering legal questions from from ASAE members all the time. And, we had this understanding, and I would always kind of give a disclaimer to them that I can't give legal advice. I'm just giving basic legal education and basics on those sorts of things. And it's very true. So you need to be very careful. And whether you're an attorney, that it's permitted both by your, by your bylaws, by your articles, and by your state statute. There's no problem saying that. Where it gets tricky is when you drill down to a deeper level and you ask to see all of the, all the specific provisions, and then you're giving them advice on what to do. That's where I generally draw the line outside of an attorney-client relationship.
Thank you. We're hoping to hold our annual meeting via Zoom, usually held in person, and want to take a vote on the approval of our proposed bylaw changes. We're hoping to just use the Zoom polling information for voting. Would this work?
So first off, it's going to be probably the answer to most of these questions. You need to consult the state statute and your own bylaws to see what's required. I have seen some provisions that refer to electronic voting mechanisms, for member votes and things like that, like in the state statutes, and they say that you have to be able to identify and verify, the individual or the company, if it's a trade association, of who's voting, like for a member vote. So first off, if you're in a state like that, that polling feature is never going to work, right? On the other hand, if you're not, and those types of provisions are not as common, but if there's nothing in the state statute that's that specific and prescriptive, and it just talks about, requirements for a membership meeting, notice requirements, quorum requirements. Obviously, you're following all of those things. Presumably, the state statute allows for a virtual membership meeting. As I said earlier, a few of the states do not. But assuming you're in a state that does allow for a virtual membership meeting, analogize it to an in-person meeting, right? You have an in-person meeting, your annual meeting, right? You gave notice, you're sure you have a quorum because you just look around the room and you clearly have more than the minimum number that's required to establish a quorum, whether it's 10%, 25%, whatever the case may be. And then you go ahead and you take a vote on something. You do what's called a voice vote. All in favor, aye, all opposed, nay, any abstentions, and usually everything's unanimous in these sorts of situations. Once in a while, you have a contested vote, but generally speaking, it's very clear. If you ever had a really close contested vote, then a voice vote is not going to work in that regard. But generally speaking, that's not the case. So if it's a true meeting and not like an action outside of a meeting, if it's an action outside of a meeting, some sort of a poll is never going to work. You're going to have to be able to verify the identity of everyone that's voting. But if it's an actual meeting, a Zoom call, and there's a clear majority when, no question there's a quorum and no question that it's a clear majority or it's unanimous, then yeah, I think the polling feature could work. That's presuming that you have enough people that actually respond to the poll. If you only had a small handful, I think that might call it into question. But again, analogize it to a big, conference room, a big banquet hall at a hotel where you're holding your annual meeting or a convention center. And I think the same basic analysis would apply. So it's a great question. I actually haven't heard that before. But in that particular circumstance, I think that would probably work.
Thank you. Here's a clarification question on something you referenced earlier. When you're referring to working out, when you're referring to voting outside of the meeting, are you suggesting that one, you can have a virtual meeting, and then two, you can have a vote, an electronic vote that follows?
You theoretically could. Usually that doesn't happen. Usually it's, one or the other. You either have a virtual meeting, like we just gave the example of the Zoom meeting, and you have some kind of a voice vote using the polling feature during that meeting. I have seen, I haven't seen it yet. I'm sure it's happened for membership meetings. I've seen it for board meetings where in the last couple months, a number of association boards have had kind of board meetings by Zoom, but then at the same time, they're using, some of these board technologies and softwares that allow board members to do all sorts of things like access the board materials and vote and other things using that particular platform. For board meetings, that works very well. For a membership meeting, that's going to be a lot more difficult to do, obviously. But assuming you have an actual, Zoom type meeting, then anything that takes place at that meeting is just going to be subject to the general rules for membership meetings, which is people can make motions. Like I said, we could probably use the voice vote approach to that sort of thing. But if you're going to have an action outside of a meeting, it's usually because you're not going to actually hold the meeting itself, virtually or in person. And so instead, it's essentially just like doing an old-fashioned mail ballot. Like if, back in the old days, you would mail out the ballots to everyone. They would check, who they're going to vote for officers and directors, and they would mail it back in. Nowadays you do it with, these electronic voting platforms. You open up voting on a certain date, and you leave it open for whatever it is, 10 days, 20 days, 30 days, and then you close it, and then you announce the outcome. And usually using one of these companies, one of these vendors that does it and verifies it and ensures the integrity of the process. It's usually one or the other. But it's certainly conceivable that you could have a meeting where you tee up and talk about issues and debate and discuss, and then following the meeting, you have a membership vote electronically to actually vote on it. So that's certainly permissible.
Thank you. This comes from an association that's headquartered in DC. She says, we usually hold our elections at our annual meeting, and the attendees are the only members who vote. If we hold a live annual meeting with virtual capability, will we also have to live stream the business meeting part and allow remote attendees to vote?
Not sure I understand the question. First off, when we refer to the annual business meeting, that is a term a lot of state statutes use that. That means the formal annual membership meeting. We're not talking about, in the loose sense of the term, the whole conference. We're talking about the actual business meeting part, which frankly, in most associations, it's like less than an hour. It's kind of a pro forma thing. You're doing it because you have to. And it's a very, quick and dirty type process. But to constitute the annual business meeting of the members, it would require notice to all the members. Notice is always required for these sorts of things, and there's different ways that you can provide notice, but you have to provide notice. You have to have a quorum, and then the members have to be able to participate. So again, I'm not sure I completely understand the question, but that would be required. You would have to invite them and give them a chance to participate, give them a chance to speak, and then if you're going to take a vote at that meeting. And by the way, if that doesn't answer your question, feel free to follow up with me separately. You see my contact information up there. I'd be happy to help.
You had referenced, quote, nonprofit corporations code, unquote. Would we normally be covered under the general corporations code?
So it's a great question. And I didn't refer to the nonprofit corporations code, although every state calls it a little something different. Most states call it their Nonprofit Corporation Act, or like in New York, it's the Not-for-Profit Corporation Act. In Virginia, it's the Non-Stock Corporation Act. It's all the same thing. It's a state statute that governs nonprofit corporations that are incorporated in that state. And much of those provisions relate to governance-related issues. In most states, the Nonprofit Corporation Act or statute, again, same interchangeable terms, are separate and distinct from the general corporations code or act or statute. Again, all the same thing. Code, act, statute just means a piece of legislation that's been enacted. So in most states, the general corporations code or act for-profit corporations is different than the nonprofit code. There have been many, many instances over the years where I've seen people make mistakes by relying, just Googling, looking up something. It's easy. You can find all these codes. They come up really quickly. There's like a site called Justia, Justia, that has all of these codes on there. It's really easy to pull the stuff up. Back in the day when I started practicing, you had to use these expensive services like Lexis and Westlaw in order to access that stuff. Not anymore. But if you're going to do that and do a little homework on your own, or your chapters are, they don't, they want to figure out some of these things without hiring legal counsel, make sure you're looking at the right statute, the nonprofit one, not the for-profit one. Now, to make it even more complicated, there are a small handful of states, Delaware being the most notable, where it's really complicated. And it's one of the reasons I don't like the Delaware statute for nonprofit corporations, is that it's all intertwined. You have like this basic corporations code. It's just a single code, but then you have some special provisions that say, okay, for this section and this section and this section, nonprofits are going to be treated differently. Or where it says shareholders, we mean members. And so it's very difficult to read and understand. There's also the case law helping to interpret that is much less helpful than it is in other states. So, that's one example where it's so intertwined, it becomes a little more difficult to manage. But in most states, thankfully, they're two separate statutes.
So, Jeff, you may have alluded to this in what you were just talking about, but there's a couple of different questions asking, is there an easy way to determine the status of all these various points by respective state? An easy place to find your state's nonprofit.
Yeah, look, I would say you're in, I don't know, I'll just pick DC. If you Google District of Columbia Nonprofit Corporation Act, it'll come right up. Like one of those sites like Justia, and actually I think in DC, the actual, like the DC City Council, or whatever, the government itself has a site that's actually fairly user-friendly where you can access the code provisions. But whatever, some states it'll come from the government agency, some it'll come from an outside service. But find your state statute. These things can be a bit tricky. This is where it's a little bit difficult to, do-it-yourself legal work can be a little bit dangerous in some of this stuff, because you'll look at it and it'll have a section for board of directors, or sometimes I'll say directors, and then officers, and then it'll have a section for members. Sometimes it'll have a separate section for meetings, and then subsections for board meetings versus membership meetings. My point is that you're not going to find typically everything in one place, and so it can be a little bit dangerous to rely on one thing that you read, but you skip the whole other section that had some other relevant information that put some limitations on it. And unfortunately, these things are not all written and structured in the most user-friendly ways. So you might be reading one provision and you think, oh, there's no prohibition here, this must be okay. But then in another section, it actually gets more prescriptive or prohibitive in certain types of conduct. So first thing is, get a handle on your state nonprofit corporation statute for your state of incorporation and understand those provisions, and make sure you have the most current version, because these things do get amended on a fairly regular basis. The second thing is to look at your articles of incorporation. Many associations, when they're analyzing these things, they only look at their bylaws and they forget about their articles of incorporation. In fact, whenever I start working with a new association client, I always ask them for their bylaws and their articles. Sometimes they don't even have a copy of their articles. And you want to make sure, by the way, you have the most current version that's on file. So articles of incorporation, unlike bylaws, get filed with the state of incorporation, and any amendments to the articles have to be filed with the state. Whereas bylaws generally don't get filed anywhere. You provide a copy to the IRS when you first seek your tax exempt status, but other than that, they don't get filed with the state. And so it's really important that you have the most current version of your articles of incorporation. You can pull those from the state, usually for a small fee. Some states you can do it electronically, some states it's a more cumbersome process, but make sure you pull the most current version of your articles, because that may have some relevant provisions. And like I said earlier, there are certain provisions that if it's not reflected in your articles, you're not allowed to engage in that more permissive conduct. And then finally, taking a look at your bylaws, and then don't forget your policies too, because some associations have very robust and detailed board approved policies that regulate a lot of governance issues. And so while your bylaws may be silent on something, your policies might have more specifics. So you got to look at all four of those documents: the policies, the bylaws, the articles of incorporation, and the State Nonprofit Corporation Act, the relevant one, and see how that all relates together. There's really no other way to do it. And every time that myself, my colleague, analyze these issues for associations, we look at all of those things. We ask for all of those things because that's what's going to dictate the answers.
Thank you. Do bylaw provisions that require a written ballot generally allow the ballots to be emailed?
Yeah, it's a great question. So it's a question both for the state statutes as well as for the bylaws themselves. Like I said earlier, back in the day, these state statutes all referred to either written ballot or mail ballot. Many of them have been updated over the years, as has the Model Nonprofit Corporation Act, to say that mail ballot or written ballot can be by email or other electronic means as long as you can verify the identity of the voter or the sender or whatnot. But some of them have not, and even some bylaws have not. My approach over the years has always been that unless there's some reason to expressly believe, like for instance, if this is way too detailed for this webinar, but in what's called statutory construction, when you're analyzing a statute, you look sometimes to see, okay, if the legislature changed something in one section to allow expressly for electronic voting, but they did not do it in another, the way you're supposed to interpret that is that maybe they didn't intend for electronic voting to be allowed in that other circumstance. But generally, if that's not the case, or there's, like I said, there's no other reason to suspect that electronic balloting is prohibited, my approach in recent years has been to advise clients that unless something like that is the case, that if it says mail ballot or written ballot, you can generally interpret that to mean electronic balloting. Again, so long as you have some confidence in the verification mechanism.
Great. If you have a slate of officers or board members recommended by the nominating committee for a teleconference annual membership meeting, and in this case, it looks like the slate went out to members 6 weeks in advance, can you take a voice vote for the slate? Assuming you can call the vote, everyone's privacy would be protected because you wouldn't know who voted how during the voice vote. Is that legal?
So this is the same question, essentially the same question and same answer I gave earlier, which is if this is an action, this, again, it helps to illustrate one of those key points. You got to distinguish between an actual meeting, say a virtual meeting, from electronic voting outside of a meeting. Two different constructs governed by two different provisions in the bylaws and governed by two different provisions in the state nonprofit corporate statutes. You have to figure out which one it is, okay? So if it's a meeting, like a Zoom meeting or something, and again, you did proper notice, you have a quorum, and then you do a voice vote, and it's clear that there's a clear majority in favor of it, I think that would be fine. If, on the other hand, it's not a formal meeting, you haven't gone through the steps to follow the requirements in your, I mentioned earlier at the beginning of this, an example that the Virginia Non-Stock Corporation Act requires a minimum of 10 days notice for any membership meeting. So if you were incorporated in Virginia, you'd have to follow that 10-day notice requirement. Assuming you did all of those things, then a voice vote would work. But if you did not do those things, and it's essentially an electronic vote outside of a meeting, then no, I don't see a voice vote working for that. And then just as a reminder, you have that other option that if it does constitute an actual meeting, a virtual meeting, you have the option to use electronic proxies as well.
Okay. Our quorum for the business membership meeting is a percentage of voting members in the room when the meeting is called to order. How does that translate into elections and voting and electronic voting?
Yeah, so it's a great question, and what that means. So let's say the quorum requirement is, generally most state statutes say you can set the membership, the quorum for membership meetings as low as you want, but not lower than 10%. That's generally the lowest level that I've seen. Actually, some of them say it could be anything. I take that back, but generally best practice is never to have it be less than 10%. But let's say it's 25%, which is fairly common. If, let's just say you had, not realistic in most cases, but say you had 100 members, 25 constitute a quorum, 25%. In the, in an in-person context, you would count, do we have 25 voting members? And again, distinguish between voting and non-voting. Most associations have categories of non-voting members that don't count for these purposes. They can't vote and they don't count toward a quorum. But you have 25 voting members in the room, and then from that you have a quorum. And so a majority of, basically once you have a quorum, then a majority vote is going to carry the day. Essentially what I call a majority of a quorum. If you're doing this in a virtual meeting, it's going to be the same rules. Again, majority of a quorum. Now, I think the question goes to if you're doing it outside of a meeting, you're doing a vote outside of a meeting, the way that these state statutes work and the way that most bylaws are written is they'll say, anything you can do at a meeting for member voting, again, not board, but member, you can do outside of a meeting, and it's going to be subject to the same quorum and approval requirements. So if you were taking electronic balloting outside of a meeting, you would still need to have that minimum 25 voting members participate, and then a majority of those voting would carry the day. If you did not have that minimum 25 voting, it would not be an effective vote outside of a meeting. That's a great question. Actually, something I should probably add to the PowerPoint presentation.
Thank you. We're down to about 4 minutes left. There are lots of questions here. So if your questions hasn't been answered, again, Jeff's contact information is up on the screen. I think one last question here that is takes us to the next level, if you will, of what's going on out there. After face-to-face meetings and events are again allowed, what is the organization's liability if an attendee gets sick?
First off, most people in these quarantine times, they're doing a lot of work from home, and then they'll catch up on their favorite shows at night. What I tend to do is catch up on my work and then write articles and come up with new webinar topics. And just last night, I was up until about 3:30 a.m. writing a new article about how associations and nonprofits can minimize their liability risks as offices reopen. And I'm happy to, I just completed that, and it's on our firm's website, and I'm actually told Mark I'll share that with him to share with all of you. I was actually intending to write the article to make it a two-part article, one about kind of how to mitigate liability risks when you're physically opening your offices, particularly risks to your employees. And then a second part is how to mitigate risks for conferences. As I got into it, I realized the second part was there was some similarities, but a whole different animal and a lot more complex. And so I did not get into that in this article. That would have to be the topic of a future article and another late night. But I can tell you in short, and for those of you that have seen one of the many webinars that I've done about kind of meeting cancellation, contract issues and whatnot, or read my article on that, I touch upon that a bit at the end. In short, what this is going to be is we're generally talking about tort liability in terms of potential liability risk to an association as a meeting sponsor, whether it's basic negligence or recklessness or gross negligence or reckless misconduct, whatever the particular standard may be for liability, all with different consequences. But the basic idea is going to be, what is kind of the established standard of care that is required for you to try to protect the health and safety of your attendees, your exhibitors, your sponsors, your employees, et cetera, on site at an in-person meeting. Where does that come from? Well, similar to what I wrote about in my article about workplaces, it's going to come from a lot of different places. You always first and foremost look to government agencies. In the workplace, you got OSHA and you have the CDC. Neither one of which has been particularly forthcoming with respect to a lot of specific guidance when it comes to workplaces. The CDC did put out some guidance about 2 months ago, kind of at the very start of the pandemic, at least start here in the US, about large gatherings and kind of best practices that they recommended. I suspect that as we get closer to more large gatherings becoming more likely, I hope and expect that CDC will update and expand that guidance. You have to look there. A lot of states and even cities and counties are starting to put out guidance, as I'm sure you've seen, first and foremost for the types of businesses that are opening first in certain states and cities, like restaurants and other small businesses. As we start to get to a phase where larger meetings and conferences occur, I suspect you will see kind of some of it will be mandated requirements and some will be guidance from states and cities and counties that you're going to need to follow. And then there's going to be associations, not ironically, in the meeting space that will put out guidelines and standards. And essentially all of this collectively forms kind of the standard of care. what are the best practices, the expected standard of care. It essentially forms a minimum that you're going to have to meet if you want to try to avoid liability risk. So if you don't meet those basic, established, widely accepted minimum standards, and someone contracts the virus at your conference and can prove that they contracted the virus at your conference, that latter part being a critical point that is going to make establishing liability a lot more difficult. But if all of that could happen, then someone might be able to bring a claim that you were negligent in not following proper standards. But if you follow all of those established best practices, even if someone could prove that they contracted the virus at your conference, and usually the only way that's likely going to happen, I mean, who knows for sure with what sorts of testing and other things might come out in the future that can identify different virus strains and whatnot. But generally speaking, unless there's a mass outbreak at your conference, it's going to be harder for someone to prove they contracted the virus at your conference. But even if they could prove it or make it, likely be able to prove it, if you meet that minimum standard of care, you're probably going to be very well off. What is that minimum standard care? How it's defined? What's the checklist of all of those things? It's very much in the process of evolving. I've seen, and I'm actually keeping a file with a kind of collection of a lot of these best practices, because I'm going to increasingly get questions from association clients is, what is that standard of care? What do we have to do to protect ourselves and our attendees and our staff at our conferences? Right now, it's very much an evolving matter.
Thank you very much for all of your insights today, Jeff. That does take us to the top of the hour. In fact, just a couple minutes past. So we're going to wrap up today. Again, if you've got follow-up questions for Jeff, please feel free to contact him using the information on the screen. And as a reminder, we will be tomorrow sending out the links to the recording of this webinar, as well as the article that Jeff has already written and the article he just referenced that he wrote last night. So we will be getting all of that information out, posted to the ASA site, and then shared to you via your local SAEs. Thank you once again for joining us. Stay safe out there and have a great rest of your day. Bye-bye.